I see my name tag and my microphone have been fixed so that I can't destroy them again. The matter before the court is State of Maine versus Craig Woodard, and this is Hancock 23-466. Again, we are being streamed live on the web. If counsel would identify yourselves by saying your names for the record, please, together with the party you represent, starting with the appellant.
Good morning, Rory McNamara for the appellant, Craig Woodard.
Thank you.
Toff Toffolon, State of Maine.
Thank you. And Mr. McNamara, if you're ready to proceed, we'd be happy to hear your argument this morning.
May it please the court, counselor. There were two significant problems with the court's self-defense instruction.
So, Mr. McNamara, I see that the green light is on.
Yes.
With regard to the self-defense instruction, my understanding is that you are appealing and saying the jury should have been instructed on defense of others as well as self-defense, correct?
Correct, third parties.
Isn't there a waiver here where there is an affirmative agreement to the instructions as given?
No.
Not just harmless error, but waiver.
I'm not sure about the harmless error part. Put that aside for a second.
Not harmless error. I mean, not just unpreserved, but waiver.
Oh, okay. Waiver as opposed to obvious error.
Correct.
Correct, okay. So the waiver in this case, and there is a waiver, it is not, however, about a 108 defense. It is about a section 104 defense.
Well, there was a more explicit waiver on that, and there's no question about that.
Right.
But haven't we held that just even by agreeing to jury instructions, with regard to the defense of property, they went through quite a bit more of a colloquy about it. But just by simply affirmatively agreeing to the jury instructions, isn't that a waiver?
So in other words, after jury instructions, when the judge says, are there any further objections?
No,
Are there any...
before they instructed,
I see. Before
in this case,
in the charge conference, sure.
he explicitly on the record said that he was satisfied with the instructions.
So this court has said, and other courts have said, that the standard for a waiver is a knowing, intelligent, and voluntary rescission, giving up a waiver of rights here. And the problem with inferring a waiver of the kind Your Honor is talking about from a record like this is there's no indication at all that trial counsel or the judge contemplated either a third-party defense or the caveat to the duty to retreat when someone is in
regarding waiver, are you saying you have to say it out loud, or can you do it by actions, by acquiescence?
I think the case law, speaking broadly about waivers in general, it's possible to do a waiver explicitly and implicitly. However, what's very important to say about this case is there is just no indication that there was any knowledge or understanding of those two components of the self-defense instructions. In other words, they didn't discuss them and say, no, I don't want those. They were just omitted.
While we're talking about self-defense, can we just set the stage here?
Please.
As we know, your client and the victim got into a big argument on Facebook, and it really got heated, and they're throwing stuff back and forth. They're both mad at each other, and they decide, let's together and fight this thing out. So
Right.
far, so good?
Right.
So the victim drives to your client's house, the defendant's house, and walks partway up the driveway, and they're trading threats and vulgar accusations and things like that. And the victim's at the end of the driveway saying, come on down and fight me, but your client is reluctant to leave his property. So the victim turns and starts walking away, and your client starts shooting at him. He's firing off a bunch of rounds and hits him with one of them. Now, the victim here never used deadly force, never did. He made some threats. You're going to tell me about the threats he made in just a second. But you agree that he never actually pulled out a weapon. He never came close enough to cause physical harm to him. What in the world would allow your client to pull out deadly force to defend against that situation?
Well, I do have a couple of factual disagreements with that. As Your Honor knows, the standard for evaluating the necessity of instruction for self-defense is whether or not it becomes a reasonable hypothesis. And here there was testimony by the defendant's father that at some point before he was shot, the victim, if you will, the man who was shot, Forrest Dale, reached behind his back as if reaching for something. There was also testimony that the car parked at the end of the driveway, someone got out of that and had an object in his hand. And that the father, at that point, this is the final shot of, I believe, 6 shots, the testimony was a little unclear, fired a warning shot again at that point. So that indicates, I think, that that threat is ongoing. Now,
Well,
also,
Can I cut you off just for a second?
please.
You said 1 warning shot. I thought the record reflected that there were 3
Thank
warning
you.
shots, and then there
Thank
was the
you.
shot that actually hit the victim in
there, and this is another part where the testimony is a little uneven. There were either 2 or 3 warning shots. The testimony from my client's father saying that at that point, Mr. Dale was continuing on up the driveway. And this part is crucial, I think. The directionality of the shot, the entrance wound and the exit wound, shows that Mr. Dale was
He was shot in the
turning.
butt.
Well, it was turning. It goes, and the picture is not in the evidence. It stayed in Hancock County, but the picture of the butt shows it at an angle, if you will, indicating that it was during the turn rather than walking down the driveway. Now, Mr. Dale testified that he is a very fast individual. He's a fast runner. In fact, he runs marathons. It becomes a factual determination for the jury to say, well, was at 80 feet away this threat so imminent for it to be reasonable for my client
Well,
to shoot?
you got the self-defense general jury instruction, correct? So why, what additional facts? I mean, why, if the jury rejected self-defense of your own person, how could you be prejudiced by not getting the jury instruction for protecting third persons and house?
Let me start with the most obvious part. The part that absolutely was not there was the caveat to the duty to retreat. The duty to retreat being generally with self-defense. If you can reasonably do so in a safely manner, you should retreat before firing. However, when the person being protected is in the dwelling home, in a dwelling, a home, in the family home, is the uncontroverted evidence here, there is no such duty. So that part simply wasn't given. And that
Well,
is
there's
something,
no evidence that any person who was in the dwelling was even aware of what was going on.
well, there is evidence of that.
That they were aware of what was
Yes,
going on at that
the
moment?
father, in fact, and my client both warned the mother of my client's child and my client's child, you should come into the main house rather than in the RV because these threats, there could be shots fired, and you need to come into the house. The father twice called police before the shooting occurred. So this was taken very seriously
So
by
what
those
you're
inside the house.
arguing is that if he is defending someone else as opposed to himself, well, back up for a second. If he's defending himself, you agree there's a duty to retreat if safely can be done so, correct?
Well, this is where it gets a little sticky. If he's also defending somebody who's inside the house, because I think there could be dual purposes.
If it were just defense of self, there's
Yes.
a duty to retreat.
Yes, if he's not present in the home, correct.
And you're suggesting that if he's defending someone else, that there is no duty to retreat on the part of either your client or the person he's defending.
That's correct, and that comes pretty clearly from the statute. That language is clear.
What do we make of the things that he said to your client? I mean, they're both pretty riled up, and he's yelling at him, and he says, "I'm going to kill your whole effing family." All right, B, you want this? I'm going to kill your whole effing family. So these are verbal threats.
Right.
At the time, not accompanied by a weapon or a means to make it happen. Do we take anything from those verbal statements,
Those
other than context?
What we take from them is there was a need for a proper self-defense instruction, I think, at base. That's where we take it from an argument standpoint, and it's up to the jury, properly instructed in the law, to decide whether or not they believe that evidence is so
If the
credible.
if the jury concluded, as we have to assume it did, that your client was not entitled to protect himself from imminent deadly harm, on what basis could the jury have found that someone else, your client was entitled to protect someone else from an imminent deadly harm?
Well, I started by answering that question. I think Justice Connors started down that alley, and I saying there's two aspects to the error. One of them is this duty to retreat. The jury could possibly have found the reason there is no permissible self-defense in this case is because, well, he should have retreated, when in fact he doesn't have that duty to retreat. And now, focusing on the notion, I think,
Well, isn't there no duty to retreat when you're within the dwelling, though?
so I can read the statute. It's retreat from the encounter, except that the person or the third person is not required to retreat if the person or the third person is in the person's dwelling place. So it's pretty expansive there. It's covering.
And he clearly wasn't, although you're
Correct.
suggesting the third person was.
Correct.
Can I go to the other issue, another issue that you
Please.
raised while we have very limited time here, which is the mandatory minimum sentence of
Yes.
4 years. So by statute, by law, if the state pleads and proves that the offense was committed with the use of a firearm against the individual, there's a mandatory minimum sentence of 4 years, and the judge applied that, correct?
Unsuspendable sentence, yes.
The allegation in the indictment was, in fact, that the offense was committed with the use of a dangerous weapon, specifically a handgun, correct?
Correct.
And there's no other weapon involved in this case other than that gun.
I would say that that's probably correct, yes.
Yeah, I think it's more than probably correct.
There was
but-
another weapon with the father.
Okay.
But that's
So,
put
I mean,
aside.
didn't the jury, in fact, find that the state pleaded that he committed the offense with a dangerous weapon, specifically a handgun, and the jury, in fact, found that he did so? I don't understand what the problem is.
A handgun is different than a firearm in some circumstances. It's open to interpretation of a juror to say, is that handgun a firearm?
What kind of a handgun is not a firearm?
Well, personally, if I were a juror, I would not say otherwise. But as we know, and one of the reasons why jury trials are often chosen over bench trials is that jurors sometimes decide cases with an eye towards lenity or a mistake
On what
or
ground was there for
compromise.
them to just conclude it was anything other than a firearm?
I think that, well, I think those three things, lenity, compromise, and mistake. And that's in particular where we have a case with two grown men acting childishly, if I may disparage my own client for a moment. That is a possibility, to have a compromise verdict, to say, well, we're upset with everybody
Where's there a
here.
compromise, or at least a thought that was incorrect, that there was a firearm to the extent that it discharged bullets?
Well, no, a compromise verdict being, we're not going to find that aggravating circumstance. We may find him guilty, but that aggravated finding may not be something we find.
Thank you, counsel. Mr. Toffolon?
Well, we don't want to encourage juries to make their judgments based on mistake, compromise, or lenity. If I may respectfully amplify on Justice Meade's recitation of the facts, the victim was never on on the defendant's property. He was 1,500 feet away from the property.
Mr.
when he was
Toffolon, let
shot.
me suggest that somebody shooting a handgun at center of mass is probably not going to hit the other person at 1,500 feet.
I'm just reciting what the trial testimony was, Judge, but even
Well,
if you
that was your argument, that it was
I know.
1,500.
Even if you reject that, he testified, I never entered the defendant's property. I made a conscious decision to have this fist fight on public property. And further to Justice Meade's
But
account-
wasn't there evidence in the record that suggested that he both threatened the family members and that the family members were there?
I don't
You
think
may
that
not agree with that, but there was evidence, wasn't there, to that effect?
oral threat, but he threatened to burn the house, right? And he held up his hands. I don't have a gun. I don't have a gas can with accelerant in
But
it.
before he got there, he had certainly threatened to harm the family, hadn't he?
In the verbal or in the
Okay.
digital banter, yes.
Yeah, and if the evidence is generated, shouldn't there have been an instruction about defense of others?
The evidence wasn't generated because I come back to the seminal point in this case. The victim is in full retreat, running, weaving as he runs toward the public road when the shots are fired at him. So there was never
Which is
defense.
why you're probably going to prevail on the point, but the self-defense instruction was given. And the question is, should a defense of others, when the guy had also threatened the family, should that instruction have also been given?
No, the state contends that the self-defense instruction wasn't generated, but that's the judge's prerogative, and he gave it.
Is the reason, what role does the reasonability of the person using force come into the picture here? As you know, that the statute says a person is justified in using deadly force upon another person when the person reasonably believes it necessary and reasonably believes that the other person is about to use unlawful deadly force against him. So the reasonability of the guy using the deadly force, what's the role of that here?
I don't think the court needs to reach that, because the trial opened up with trial counsel showing a giant picture of the wound in the victim's leg, and it went in here and came out here. There is no possible way for a jury to conclude that it was anything but a shot that hit him as he's in retreat, which was the state's case in a nutshell. You don't reach self-defense, Judge.
Mr. McNamara says it might equally be the fact that warning shots are fired, so he is turning to run, and he gets them just in the moment of immediately backing off his aggressive stance.
And that would be speculation, because that's not, in the state's judgment, what the evidence showed.
Mr. Woodard's father was outside with him. Everyone else in the family was inside the dwelling place. If it was appropriate for the court to give a self-defense instruction as to person, meaning Mr. Woodard, and the father was also outside, why was the court not required to give a defensive third-person instruction?
Again, because the self-defense in general wasn't generated. I would also respectfully point out that Mr. Woodard, the elder, was also armed, and I think he took a shot. So he's lucky he wasn't charged with the crime himself. But to respond, Justice Horton, directly to your question, again, I retreat, no pun intended, to the overwhelming factual scenario here. The victim who got shot was back to running for his life, because he saw the defendant reach behind the tree to a table which just conveniently had a handgun on it, and he knew what was coming and attacked.
So I understand why you would take the position, and the jury obviously agreed with you, that it wasn't a self-defense situation. But our case law is that if the issue is generated by the evidence, there should be an instruction. And in this case, Dale, the victim, yelled, when he gets there, I'm going to kill your whole effing family. I mean, he kept saying, I'm going to kill your whole effing family. How is that not a threat to the family?
We get back to the reasonableness of concluding that that was anything
But that's
more than
another
violent
issue.
death.
The jury certainly could reject under all of the circumstances that it really was self-defense, and they did indeed do that for self-defense. But the question is, should they also have been instructed that he had a right to defend his family?
Well, then I'll take advantage of your remarks, Judge, about the concept of waiver. It seems clear to me that a very experienced trial counsel went through the self-defense instructions very carefully, made a tactical decision about what he did and did not want. There's no plain error because he didn't ask for it, he waived it. And again, as I point out in my brief, I'm not taking any position as to whether he was competent or not, but that's a PCR issue.
Counsel, putting aside the waiver issue for a moment and just looking at the issue kind of in the abstract, if the evidence here was sufficient to generate a self-defense justification and the father was there, had been previously threatened, what I'm struggling with is why wasn't it sufficiently generated to give a defense of other instruction as well?
Because, again, I hope this court will decide that the self-defense instruction wasn't necessary to begin with. But
But usually, even if it's imperfect, I mean, in this case, the defense waived any instruction as to manslaughter or a lesser included. But one of the importance part of the importance of the instruction on self-defense is that it can be an imperfect self-defense, correct?
That's true, but where would that request have been generated? The state certainly wouldn't ask for more restrictive instructions than were necessary to meet its burden of proof. It lay on the defense to ask the instruction for the instruction. The judge was not required to give it unless this court decides there was plain error, but it wasn't generated.
Well, when
and-
it comes to self-defense, because that's considered an element that the state must disprove beyond a reasonable doubt, there is a different standard for reviewing that, isn't there? In other words, if it is evidence in the record, then it is obvious error not to give that instruction.
I'll concede that, and I'll indicate to the court, as the record does, that we did meet our burden to disprove self-defense. That doesn't really respond to the court's questions about the third party's self-defense.
As you know, the court has set the standard for giving self-defense instruction fairly low. You have State versus Bard, in which the case, when I was on the trial court, I didn't give a self-defense instruction, and I was reversed by this court in later years and felt, well, okay, the standard's pretty low. So you have that. But actually, I'd like to ask you about sentencing. As you know, in the second step of sentencing, the court looks at aggravating factors and mitigating factors. If they're aggravating factors, the sentence is going to go up. If they're mitigating factors, they'll go down. And here the court, the second step, said the defendant's age at the time of the incident is significant to the court. He was 30 years old at the time. This is not a youthful indiscretion. That sounds to me like he used the fact that the defendant was 30 years old as an aggravating factor. Do you read it the same way?
I can read it the same way with perfect accordance to Justice Larson's sentence.
So
We
you think
just wrestled with this
So,
last month.
exactly, yes. Deja vu all over again.
Right.
So is it appropriate for a court to obviously, well, not obviously, but perhaps in some instances, he refers to youthful indiscretion. Maybe a young person might be mitigating the fact that their judgment wasn't fully evolved. But is the opposite true? Does the fact that a person has reached the mature age of 30 and made a mistake of judgment, can that really be used as an aggravate, not lack of mitigating, but an aggravating factor?
Absolutely. I had the privilege of doing many, many sentencings in front of you when you were on the trial court, Judge, and I'm sure I talked about my client's age as either a mitigating or an aggravating circumstance.
But just because something might be a mitigating factor, in other words, extreme youth or immaturity, or as well extreme age, doesn't necessarily mean its absence is an aggravating factor.
I respectfully disagree, and I hope the court is not on the verge of announcing a rule that the sentencing courts can't consider age. It's fundamental. We mature.
But doesn't there have to be at least some connection? I mean, some logical conclusion that it makes it much worse because you're 30. I mean, this is an adult criminal offense. Of course, other than maybe, some excuse for youthful immaturity, everybody is an adult if you're charged.
And I can respond directly to the court's question by quoting Justice Larson, who talked about a pattern of conduct. So he didn't consider age in a vacuum. He considered it in association with a pattern of conduct on the part of the defendant. And the defendant elocuted and talked about the struggles he had as he was growing. So that was something he injected into the sentence.
So let me ask you a hypothetical question. You got Jones and Smith. Jones is 18 and a half. Smith is 45. They both do something really stupid. The fact that Smith is 45, is that an aggravating factor that he might have not used against, I got my Jones and Smith mixed up, but the other guy, the 18-year-old, is that okay to say simply, you're 45, you should have known better, but you're young, so we're going to give you a break? Is that okay?
I hope you quote me kindly in your written opinion, but I'm going to say unambiguously, yes, age matters.
Is it clear from the record here that the judge used that as an aggravating factor or subtracted it as a mitigating factor?
I think he used it as an aggravating factor, but not in a vacuum, because he talked about the life experiences. And part of the reason he talked about it is he was responding to the defendant's own elocution, and so he was perfectly permitted to use that in whatever fashion he saw it to be reasonable.
Why didn't you allege in the indictment It is typical to allege in the indictment, if you want the mandatory minimum, that it was committed with the use of a firearm, and you know, maybe referencing the statute, although referencing the statute is not part of the charge. That wasn't done here.
Two answers to that question. One, the statute makes that a moot point. It defines a firearm as including a handgun. Secondly, more
Well, it
practically.
doesn't define it as including a handgun, it defines it in other ways.
Which clearly include a handgun. Plus, we have the testimony about the bullet, which everybody conceded it was a bullet that injured. But as a practical matter, Judge, it's because when Justware coughs up these charges with the templates, it makes you identify the particular weapon. It's a motor vehicle, it's a knife,
Yeah,
it's
but
a
there's a
handgun.
difference. I mean, isn't that significant in sentencing? You know that there's a difference between use of a dangerous weapon and use of a firearm. And this said use of a dangerous weapon, and then it wants you to identify it. I get that. But why would it not be alleged specifically use of a firearm?
Again, I retreat to the statutory definition and the record evidence, but I will also remark that a 5-year active sentence on a Class A conviction is totally on the low
Well, even if the
end.
sentence is reasonable in looking at it in a vacuum, I mean, the reality is the judge felt that he was bound to impose a mandatory minimum of 4 years.
Correct.
You agree
I agree with that, but I also urge the court to find that no rational jury could conclude that a handgun is not a firearm.
And that's the question asked to Mr. McNamara. So doesn't common parlance mean a handgun is in fact a firearm? As you know, under the statute, firearm is defined as an object that can expel a projectile through the use of an explosive force or something like that.
Correct.
But in common parlance, when we say handgun, do we assume that that is a firearm?
Well, we do, Judge, but you don't even need to reach that point. The defense conceded that the injury was caused by a bullet, ergo it had to come from fire.
That was expelled by explosive force from something the guy was holding.
And the description was, I got a gun off the table and shot the victim. Ah, the yellow light. May I be excused?
I'll just say, if I may, I have one point on the waiver issue that was mentioned. Mr. McNamara's brief cites a case that he and I are both familiar with called State versus Thurlow, where I was the trial judge and he was counsel on appeal, and he pointed out that even though the parties had agreed to the jury instructions as given, before and after, I failed to give an instruction that this court found to be obvious, and this court found obvious error. So, yeah, I think a waiver in this case would require something more affirmative than simply assent to the instructions as given under the Thurlow case.
Are you asking me to take a position on that?
Yes.
I want the court to rule in the state's favor, but I'm somewhat sympathetic to that argument, because after you do an exhausting trial and the judge calls you up and asks both counsel at sidebar, are you satisfied with the instructions? All you want to do is say yes and sit down. So we'll let you wrestle with that collectively, please.
Mr. McNamara, you reserve 3 minutes for rebuttal.
Thank you. Well, we're not pleasing the court anymore. May it still please the court. I'm sorry.
We like to be pleased all the time.
Thank you all the time. I don't typically do it on rebuttal, but I thought you deserved it. To push back against the notion that the self-defense wasn't generated, previously at trial, counsel for the state argued there's some suggestion that Mr. Woodard was protecting his home and protecting people in his house. So I think even then he realized that this was generated, and he has to make the argument now on appeal that it wasn't generated. In the state's brief at page 5, the state said Mr. Dale was at best 80 feet from the house. That's certainly a lot closer than the 1,500 feet we heard today. I think if we are to Justice Horton's question about Thurlow and whether there's waiver, we can also juxtapose what very clearly happened with the 104 waiver that is absolutely waivers. A waiver of Section 104 self-defense happened clearly on the record. It took a couple pages to do that. Defendant stood up, made sure he was understanding that. And the notion that somehow the defense would also be waiving a third-party defense under 108, but not put that on the record in the same manner, I think just kind of belies the fallacy of that argument. Your Honor, Chief Justice, you hit on some important notes about the fact that 1604(3) wasn't clearly alleged in the indictment. And I think that that reminds us that there are dual functions to the Sixth Amendment. It's not just about having a jury find X or Y or Z, and I certainly reasonably they could have found that the firearm, the handgun used in this case was a firearm. It is also about notice. Notice, prosecutors have an awful lot of discretion to charge or to not charge. And then over the course of 2 years, at multiple...
And I think what you're getting at is that Mr. Juskowitz indicated that he did not understand this to charge a 4-year mandatory minimum. But wasn't that a little disingenuous on his part? It specifically did say it was committed with the use of a handgun.
Right, but he did not know that that aggravating circumstance was being charged.
But we don't ask the jury to engage in sentencing. In other words, that although the jury needs to find the facts,
Right.
whether what the sentence will be and whether there's a mandatory sentence is for the court.
It is for the court after the screening function of the proper findings, after, I would argue, the very important process of dispositional conferences, settlement conferences that clients go through, understanding, well, here's the expectation of what I'm going to get for a sentence. And if it's not clearly alleged, it's very easy to clearly allege. But if it's not done, one of those purposes of the Sixth Amendment is not fulfilled. Thank you.
Thank you. Again, thank you for your arguments in this case, counsel. And as is our usual practice, we will once more take the matter under advisement and issue a written decision in due course. And with that, we'll be in recess.